SJC-11886, Commonwealth v. Rintala.
Good morning, Mr. Hoos.
Good morning, Chief Justice. May it please the Court, David Hoos for the appellant Kara Rintala. I bring no arcane or complex legal arguments for your consideration this morning, just a straightforward application of facts to the well-known and understood Commonwealth v. Lattimore test, although it is a standard that, as the First Circuit pointed out just a couple of years ago, is as easy to articulate as it is difficult to apply. I would suggest that the Court's many decisions on this, that the better ones, the most helpful ones, are the ones that talk about four things: motive, means, opportunity, and consciousness of guilt. And the Court has taught us something about each of those factors in its opinions. As to motive, of course, we know that the Commonwealth doesn't have to show one, but if they can, it's an important consideration. And I would suggest that Cordell and Fitzpatrick are two cases for which that stands. The Court also has talked about means and the importance of demonstrating a means to commit the offense, and has noted that if there is no evidence of means, even where there is strong evidence of consciousness of guilt, motive, and opportunity, the evidence may fail. And of course, Mazza is the case which stands for that proposition. Opportunity, the Court has said over and over, opportunity alone is not enough, and the Court has made clear, probably most articulately by Justice Lynch in 1999 and Coonan, that being the last person seen with the victim is not enough. The facts in this case are really very few that are in dispute. What is tremendously in dispute is what the appropriate inferences are for those facts, or stated perhaps more accurately, what are the reasonable and proper inferences. I want to touch on opportunity for a moment, but I'm worried about falling down the rabbit hole of getting into the medical examiner's determination as to time of death, because that will take up 10 minutes easily. But I've indicated that we concede that Ms. Rintala had the opportunity to commit the crime. What we can't concede, and what the Commonwealth continues to press, is that she's the only person that had the opportunity to commit the crime. I want to talk about opportunity for the simple reason that I think there is a piece of evidence there that illustrates the broader point that I want to make about the Commonwealth seeking or asking this Court and juries to draw inferences that are not reasonable. And both of them relate to the cell phone that was found in the bed of the decedent, the unmade bed, at a time she was expected to having been taking a nap. Now, a phone call was made from that cell phone at 12:21, and we have to set the backdrop here because the medical examiner, according to the Commonwealth, had said that the body had been dead for 6 to 8 hours, even though she would never concede during her testimony that that meant a simple subtraction of 6 to 8 to 11 a.m. from the time the body was found to 11 a.m. to 1 p.m. Nonetheless, the Commonwealth picked up on that and argued that the time of death was 11 to 1. There was a call made at 12:21. Now, one might think that that would cause the Commonwealth to reassess its position. But that's not what happened, and the Commonwealth repeatedly urged that to be viewed as evidence that someone else had used the phone at 12:21. Even though there was no evidence that anyone else had ever used the phone, even though the evidence was that that phone was used to call the decedent's aunt, who she called on a regular basis, and even though that phone was found in a bed where she was expected to be napping. A couple of hours later, at 1:53, the Commonwealth asked the jury and asked this Court to infer that the decedent was dead at that time. They make that argument, or they ask the Court to draw that inference, by the fact that there was a text message sent to the decedent which was not responded to. Now, again, it's undisputed that she was left alone by the defendant in this case so that she could take a nap. The phone was found in the bed. The bed was unmade. And from that, the Commonwealth asks the jury to infer that this shows that she was deceased at the time, rather than the more reasonable and appropriate inference, which would be that she was simply taking a nap. I refer the court to the many cases in which this court has said that while inferences can be reasonable and possible, that if you have to choose between two competing inferences, then that is the kind of speculation and conjecture which the law forbids. I want to move to talk about the means that were employed to commit this murder, and I think it's important to talk about because the single justice gave very short shrift to it in her decision. She essentially, in a not even a full sentence, just said that, of course, the means were at hand. Well, actually, the means for this offense are a little different than in any others of which I've been able to find in which means have been discussed. Usually when means are discussed, it's because there's been a gun, or in one case a baseball bat, and I think another case a hatchet, which had been linked to the defendant. Here, the means were bare hands, strangulation, so in some sense anyone could have had the means. But whether this defendant had the means to commit the offense is actually a little more complicated for the defendant. There was compelling evidence that the assault that led to the decedent's death took place at the side entrance of the home. The evidence in support of that was one of the decedent's earring backings was found in the doorway. The earring itself was found at the basement of the stairs. Another earring was found embedded in her back at the time of autopsy. There was also one of her hairs that was found embedded in the door jamb. Certainly a very strong inference could be drawn that the attack that took place began in that entryway. The jury had the opportunity to see how the house was laid out and actually went on a view. The door to that entryway opens into a door to the basement. The doors do not line up directly, and there is, I think it would have been obvious, suggest it would have been obvious to anyone, and I think the Commonwealth may have even urged that there was no direct line from the outside into the basement. The bottom line of all this is that there is a fairly strong and compelling inference to be drawn that whoever murdered this woman was capable of manhandling her, and it could have been more than one person, to take control of her at the door, push her down the stairs backward because the evidence showed that all of the bruising was on her back, and then strangle her at the bottom of the stairs. I say that this is an inconvenient fact for the Commonwealth because the defendant in this case is about 5'6" tall and about 125 pounds. The decedent outweighed her by 60 to 70 pounds. And according to her longtime girlfriend, who testified as part of the Commonwealth's case, was, quote unquote, wicked strong. So I suggest that there is a real problem for the Commonwealth in establishing a means for having committed this offense. I want to turn now, in the minute that I have remaining, to talk about consciousness of guilt. And the one aspect of this, which the Commonwealth repeatedly made reference to, was this supposed laundry basket that was seen in the back of the defendant's truck. and which was continued, which was not seen when she got back. The Commonwealth asks the jury and asks this court to infer that there was a laundry basket in the back of the defendant's truck, that laundry basket contained bloody clothing and other obscene things that, may I finish this line of argument? And that they ask the court to infer that that very laundry basket is one that was later found in the decedent's truck, despite the fact that there was no blood of hers on it, despite the fact that there was no blood in the truck belonging to the victim in the case. And they asked the court to, or the jury to further assume that whoever would have disposed those things would have, for some unknown reason, kept the laundry basket. So obviously, in the limited time I have here, there are many, many other inferences that I could point to, but I think that that is one where, by the recitation that I just gave you, demonstrates that the inferences used by the Commonwealth are stacked one on top of another to the point where they are no longer reasonable. And I'll simply conclude by saying that in this court in the past year used some new language for the meaning of beyond a reasonable doubt. The inferences have to be reasonable, and at the end of the day, even with the deference that the Commonwealth gets under the Lattimore standard, it has to enable a reasonable jury to conclude beyond a reasonable doubt that this defendant committed the crime. And as this court has said, a degree of certainty, the highest degree of certainty possible in human affairs, and I would suggest that the Commonwealth's evidence falls short. Thank you.
Mr. Hoos, I just have one question. Whose blood did the Commonwealth suggest would have been on those clothes that were in the laundry basket?
Well, that's a good question. I'm not sure that they ever suggested. One of the problems, one of the many problems with that laundry basket, because there was a drop of what appeared to be blood on it that was Ms. Rintala's blood, the defendant's blood. One of the problems is that there was no evidence that Kara Rintala, the defendant, had bled during any of this, or that she was injured in any way in this supposed murder that she took part in.
And the victim had bloody clothing when found?
The victim had bloody clothing when found. Part of what the Commonwealth had alleged was that there was an attempted cleanup by the defendant, which she apparently abandoned, according to the Commonwealth, at some point, and decided on a different tactic to avoid detection. The evidence as to the laundry basket, really, no one testified that the object in the truck bed was a laundry basket, because upon my objection, I don't think the Commonwealth even seriously opposed it. It was simply not clear. One could look at it and say, well, yeah, that might be a laundry basket. So that was the first inference, is whether it was that it was even a laundry basket. The second inference was that it was the same laundry basket that was found the next day in the decedent's, in the back seat of the decedent's truck. The third inference on top of that was that DNA found on there that belonged to Kara Rintala was from that day as opposed to any other day, given that the DNA experts indicated that the edge of the basket where the DNA was found is an area where you would expect to find DNA from anyone who had handled the basket. So I point that, I use that as an example of one of the many instances where the Commonwealth just stacks inference on top of inference on top of inference to get to the desired end that they seek.
Thank you.
Thanks very much.
Good morning, Your Honors, and may it please the Court, Stephen Gagney on behalf of the Commonwealth. With me today is Jennifer Sewell, who is co-counsel on the case. Your Honors, I would ask this Court to reach the same conclusion that both the experienced trial judge in this case as well as the single justice in this case reached, in that the evidence the Commonwealth presented, combined with the reasonable inferences a jury could draw from it, is sufficient to warrant a finding of guilty here. Now, obviously, this case comes before this court against the backdrop, the procedural backdrop of the fact that the case has been tried twice so far, both times ending with the declaration of a mistrial due to a hung jury. Strictly speaking, that has no relevance to this court's analysis under the Lattimore standard, and the Commonwealth would nevertheless suggest that there is sufficient and strong evidence here suggesting that Cara Rintala killed her wife. Now, the strongest evidence the Commonwealth has in this case, and it's a thread that runs throughout the lead cases the Commonwealth cited at page 28 of its brief, Cordell, Coonan, Anderson, and Rojas, is that the evidence is sufficient for the jury to conclude that the defendant was with the victim at the time she died, and not just with the victim, but the only other person, other than the couple's 2-year-old daughter, who was present in that house at the time Anne Marie Rintala died.
And so you've established the time of death as what?
The time of death, based upon Dr. Richmond's testimony, would be the early afternoon hours, 6 to 8 hours prior to her discovery. Now, she was discovered first at 7:15 p.m., and Dr. Richmond was very clear that it is an inexact science, and for that reason, she never would pinpoint a precise time frame of, say, 12 p.m. to 1:15. But generally, the 6 to 8 hours prior to her discovery would put it in the ballpark of, say, around noon or just before to roughly perhaps 2 o'clock. And that's perhaps even broader than the doctor would suggest, but well before, this is the key, well before Cara Rintala, by her own admission, left the house that day. When she was first asked by the first responders when she left the house, at first she said, well, somewhere between 2 and 4, but then she narrowed it to 3 o'clock. And when she was interviewed the next day, the second interview she gave to law enforcement, I want to be very clear about this because there's been, I suggest, a misimpression or perhaps a misunderstanding by the defense of when Cara says she could have left the house on the early end. On day 2 of her interview with Detective Lieutenant Robin Whitney, she stated that her daughter typically went down for a nap between 2 p.m. and 4 p.m. on the days she was home. And on the day in question, after about an hour of an attempted nap, trying to get a 2.5-year-old down, which I can attest is not always easy, about an hour into the nap, or attempted nap, is when she left the house. So initially she estimates it was about 3 o'clock. But then she makes a reference to 1:30 p.m. And the reference to 1:30 is what time she may have gone into the room with her daughter to begin the attempted nap. And about an hour later, or 2:30-ish, is when she left the house. So the earliest end of the spectrum when Cara Rintala claims she left the house that day is 2:30 p.m. And that is well within that 6 to 8 hour window that Dr. Richmond testified to. And the references I've just made, as far as the second interview Ms. Rintala gave, that's been submitted to the court. There were 2 videotaped interviews that she gave, one the night of the murder and the second the following day. This is on the second interview, which was exhibit number 25 in the case. And the pertinent parts of that interview were minutes 17 through 18 and 25 through 27. So Dr. Richmond's testimony regarding time of death puts Cara Rintala, by her own admission, squarely at home, the only person at home, the only person capable of inflicting the injuries and strangling Anne Marie Rintala to death at the time she died. And that was an opinion that Dr. Richmond arrived at preliminarily on the night of the murder over the telephone. But by the time she testified, she had met with the lead investigator on the case twice. She'd met with both prosecutors who had overseen the investigation. She'd reviewed first responders' statements, their prior testimony, photographs of the crime scene, and that is what she based her opinion on. Now, the jury could very well have drawn corroboration for that time of death estimate by the fact that the victim's cell phone activity fell off a cliff after 12:21 p.m. Between 8 o'clock in the morning and 12:21 p.m., there were 57 separate instances of calls received, calls made, texts received, texts made, photographs taken on that phone. And after 12:21, nothing. At 1:53, her close friend and coworker texts her to say, "My sister has cancer. I just found out. I'm very sad." No response, in stark contrast to all of the other communications the two had had that morning. So in this case, I would suggest that time of death alone would be sufficient to get this case to the jury and sufficient for a jury to find that Kara Rintala, by necessity, had to have been the person who killed her wife. Against that backdrop, we also have ample evidence of motive, as spelled out by the prior domestic incidents, the financial stress the couple was under, obviously the means.
Well, Mr. Hoos challenges the likelihood of the means given the difference in size and the amount of force necessary to strangle somebody.
The medical examiner testified, and I believe this was even on cross-examination, that given where the victim was found at the base of the basement stairs, given the number of bruises practically from head to toe, given the wounds to her head, that it was entirely consistent with a tumble down the stairs. And the house is situated such that if somebody...
So the theme would be that the defendant pushed her down the stairs and then at the base of the stairs strangled her? Is that the...
Whether it was a push or a stumble or a loss of balance, by the time Anne-Marie reached the bottom of the stairs, she was either stunned and or unconscious and incapable to fend off a strangulation. Yes, Your Honor, that was squarely the Commonwealth's theory. It still is.
So there was evidence, medical evidence, that based on the bruising that the victim had suffered to her head, she could have been stunned.
Yes, the medical examiner testified to that. I think the physical evidence, the number of bruises to various parts of her body, the fact that there was some disturbance of shoes on the stairs, there was a plate knocked off of a shelf that was bordering the stairs, there was a vacuum cleaner.
Was it a possibility or a likelihood that she was stunned? Do you remember?
The medical examiner testified that it was consistent with, I don't think she said whether it was likely or just possible, but very consistent with her being unconscious and being incapable to fend off an attack. There was also evidence that based upon the bleeding underneath the scalp where there were some external wounds observed, that she was still alive when she was strangled to death, as well as the petechial hemorrhaging, that she was still alive before she was strangled to death. So, in addition...
Was there any evidence of struggling at the top of the stairs?
There was, as Attorney Hoos referenced, there was an earring backing belonging to the victim that was found outside the side door, like on the little landing next to a mat. There was one of the victim's hairs sort of caught in the weather stripping, but whether to say it's from this incident or not can't really be determined. The evidence at the top of the stairs, actually, the Commonwealth's interpretation of it and what we urged the jury to find was that it was entirely consistent with staging, that there was damage inflicted to the doorway in an effort to make it look as though it was a break-in. There was extensive damage to the wooden door jamb and the weather stripping, but none to the door itself. The glass wasn't shattered, the door wasn't hacked at, and the instrumentality used to inflict that hacking was consistent with a shovel that was left across the breezeway, put neatly right back where it belongs, and according to a neighbor, where it was typically found. That goes together with the evidence of cleanup. There was swipe and wipe marks where blood used to be based upon some of the crime scene analysis there, evidence that the intruder spent time at the scene after the death, something that no random intruder would do. In addition to that, there was ample evidence of consciousness of guilt. There was evidence from which the jury could conclude the defendant disposed of evidence, described inconsistent routes of travel, the manner in which she reacted to, may I finish this thought, Your Honor? Thank you. Her reaction to coming home and supposedly discovering her wife rather than rushing down the stairs and rendering aid as a paramedic She backs out of the house, takes the child and the dog across her lawn to the neighbor's house, knocks on the door, asks the neighbor to call 911, and her own declaration on the night in question that she considered herself, or at least could see how people could consider her, the number one suspect, when nobody had even determined yet that a crime had been committed. So for these reasons, Your Honor, through the Lattimore standard, I'd ask this court to make the same finding the trial judge and the single justice found and deny Ms. Rintala's petition.
All right, thank you.
Counsel.
Thank you.